Hi, everyone. Welcome to today's panel from the ACS DC Chapter. We're very excited to be presenting today on protecting the vote in 2020 on issues of both election security and voting rights. We have a fantastic panel lined up today. Obviously, these are topics that are very much on everyone's mind, and we're lucky to have experts in various areas that touch on both election security and voting rights. But before we get to the substance of today's presentation, I know that not everyone here is an ACS member or an ACS member of the DC chapter. And so I just want to thank you for joining us, even if you aren't already involved in ACS, and encourage you to get involved. The American Constitution Society is the leading progressive legal organization. It has over 200 local chapters. And do publications, networking events, conferences, and there are lots of opportunities for law students as well. So if you're not already a member of your local chapter, particularly if you're in DC, please join the ACS DC chapter or your local chapter. Again, my name is Adrienne Lee Benson. I'm on the DC chapter board on the events committee, and we're delighted to host three experts today, Sam Hirsch, Genevieve Nadeau, and Kemba Walden, to talk about election security and voting rights. And the reason why we talk about those two things separately, I think in many people's minds that are kind of melded together, is that they're actually kind of both legal and technical layers to what is happening as we get moving towards the November 3rd election day. And so our experts are going to provide kind of background on the legal landscape, on the technical and cybersecurity landscape, and the ways in which particular challenges, both political and technical and COVID related this year, are layering onto those backgrounds as we try to protect the vote going forward over the next few weeks. So with that, I'd like to introduce our first panelist, Sam Hirsch. Sam is an experienced election law practitioner and former DOJ official in the Obama administration. So he is currently a partner at Jenner & Block, which is also a law firm where I work, in the election law practice and government controversies, as well as the environmental practice. So Sam actually was instrumental in creating the election law practice and election law redistricting practice at Jenner & Block. He has been a leading litigator in election law for quite a while. Has been involved in voting rights and redistricting cases in over 20 states, and involving the Help America Vote Act, Voting Rights Act, as well as under the first, 14th, and 15th Amendments and the Election Clause of Article 1. So before rejoining Jenner after the Obama administration, he was the Deputy Attorney General at DOJ, where he supervised the Environmental and Natural Resources Division, Civil Rights Division, the Office of Tribal Justice, and the Access to Justice Initiative. And though you won't see this on his official bio, I also happen to know that Sam has lots of practical political experience, both as a campaign staffer and a high-level volunteer strategist on presidential campaigns. So, I'm lucky to work with Sam at Jenner, including on election law issues, and have the privilege of learning from his expertise and mentorship that some of you all get a taste of today. Our next panelist is Genevieve Nadeau. So Genevieve is a counsel with Protect Democracy, which, if you don't know, is a fantastic organization that was founded in early 2017 by a group of former Obama DOJ and White House counsel officials. It focuses on anti-corruption work, protecting the First Amendment, reining in excessive executive power, and protecting elections, among many other projects. So Genevieve is also an accomplished litigator, both with PD and her prior career with the Massachusetts Attorney General's Office, litigating First Amendment, civil rights, voter intimidation cases. And she currently, for our most relevant to our purposes, leads the legal and policy work of the National Task Force on Election Crises organized by Protect Democracy. So as I mentioned, prior to being at PD, Genevieve was in the Office of the Massachusetts Attorney General, including as chief of the Civil Rights Division as a state enforcement counsel. And before joining the AG's office, She was also an attorney advisor with the U.S. Department of Homeland Security. So welcome, Genevieve. And then we also have Kemba Walden. So Kemba is an attorney with the Digital Security Unit at Microsoft. So she operates kind of at the intersection of cybersecurity and critical infrastructure protection. We're very excited to have her today because she's going to bring kind of a private sector perspective on cybersecurity and election protection. So because she helps lead Microsoft's digital diplomacy team, and it's focusing on Microsoft's Defending Democracy program, which works around the stakeholders around the globe with both governments and non-government actors to protect campaigns from hacking, as well as increasing political advertising transparency to increase the legitimacy of elections. So prior to joining Microsoft, she was also working in the Obama administration at the Department of Homeland Security, where she worked in a number of high-level cybersecurity roles, including as attorney advisor for the then newly created Cybersecurity and Infrastructure Security Agency. So we're very excited to have Kemba here today to talk about the infrastructure and cybersecurity issues that go into election protection, and to share what the private sector is also doing in these areas. So we would like to just kind of begin with giving a legal background. I know that not everyone in this webinar has actually litigated these issues before, may not be a voting rights expert. And so I'd like to ask Sam, when we talk about voting rights, what does that actually mean in a practical sense of what is the background in the law? What are the kinds of claims that people can bring when their voting rights are infringed? Like, what are the actual legal issues in these cases?
Sure. Well, before I get to the answer to that question, let me just thank ACS and the DC chapter for having us at this lunch event and for putting together such a wonderful panel. I just met Kemba yesterday, and she's wonderful and terrific, but I've had the opportunity all year to work with Genevieve, who is an amazing lawyer, and I've worked now for several years with Adrienne, who is just one of my absolute favorite colleagues at Jenner and Block. So anyway, thank you for having all of us. To answer your question, everything I say here is probably going to be a little bit oversimplified and a little bit of a 100,000-foot version. We were just talking right before the panel started about how I think there's over 300 election law cases pending or recently concluded in this run-up to the November 2020 election. So there's a lot going on. There's a lot of nuance. There's a lot of details. But I'm going to try to really step back to the big picture about what are voting rights and where do they come from. And maybe the best way to do that is to think back to your con law class, where you learned about sort of the two classic strands of 14th Amendment jurisprudence. All the voting rights go way beyond the 14th Amendment, but the basic idea of sort of liberty interests or fundamental rights in one strand, and equality and concern about suspect classes in another strand might be a way to frame this. On the sort of liberty side, voting is a fundamental right. You might think from that challenges to state or local laws that limit your voting rights would be subject automatically to strict scrutiny. But under the Burdick analysis, the Burdick being a 1992 Supreme Court case that upheld a Hawaii law prohibiting write-in votes, the framework is much less plaintiff-friendly than you might think. Severe, whatever that means, severe restrictions on your voting rights are subject to strict scrutiny and generally tend to get struck down. But what counts as severe has been interpreted pretty narrowly. It really has to be something that usually blocks you absolutely from voting. A lot of the restrictions on voting rights that you think of as being things that really raise the cost and make it more difficult to vote, I mean cost broadly, not financially, those sorts of things, usually under Burdick, are labeled reasonable and non-discriminatory, and then you're in a world of a balancing test, where the court weighs on the one hand the character and magnitude of the asserted injury to the plaintiff voter against, on the other hand, the precise interest put forward by the state. But the reality is that this is a very defendant-friendly balancing test, and it's hard for plaintiffs to prevail on this sort of fundamental rights theory for a non-severe restriction on their voting rights after Burdick. So plaintiffs have an uphill climb. So what about the equality side? As is often the case, some of the equality issues that come to mind are race, sex, class. So let's go through those in opposite order. Class. Because there is a constitutional amendment prohibiting poll taxes, things that literally cost you money to vote are very vulnerable. On the other hand, when you try to analogize voting restrictions to the poll tax, often courts reject the analogy. In other words, just because something is harder for someone of low income than it is for someone of high income if they're trying to vote, doesn't necessarily mean it'll get struck down by any means. Sex and gender discrimination usually don't play a role in this kind of litigation. But when you get to race and ethnicity, that's really where often the rubber hits the road on these sorts of cases. There, you tend to see plaintiffs bringing cases under the Voting Rights Act rather than directly under the Constitution for one principal reason, which is that since 1982, when Congress amended the 1965 Voting Rights Act, it applies to instances of discrimination regardless of whether you can prove up discriminatory intent. As long as there are discriminatory results, it's potentially vulnerable under Section 2 of the Voting Rights Act. Now, most of the Section 2 Voting Rights Act jurisprudence that you might be familiar with is actually about vote dilution, where you're allowed to cast your vote, but it's somehow or other given less weight, for example, because of the way that congressional district or state legislative district lines are drawn, so that you are either packed or cracked or otherwise weakened. So your vote gets cast, your vote gets counted. It just doesn't count as much as it should compared to other people. But in the run up to this election, as in all elections, the emphasis is not so much on vote dilution, but on what's called vote denial claims. As we may discuss later, the Supreme Court just on Friday agreed to hear this term, a case that is in part about what is the proper test for a vote denial claim under Section 2. The circuits have been pretty clear that what they mean is sort of a two-step question, which is first, does a policy result in a disparate burden on minority voters? And secondly, does the policy interact with social and historical conditions to cause that disparate burden? The first step has something to do with the language of the act saying that you can't have state laws that provide less opportunity for minority group members than other members of the electorate to participate in the political process and to elect representatives of their choice. The second step has something to do with the statutory language saying you can't view the stuff too narrowly, you need to look at the totality of circumstances. But anyway, the interesting thing is there's clearly a causation element that's front and center in that test, but it's not a discriminatory intent element. In other words, you don't have to prove that the state set out to harm minority group members. You have to prove that somehow or other race interacts with the policy in a way that is causal. So that's sort of the basic lay of the land on the equality side. Now, a couple things we want to talk about in terms of complications. There's two policy overlays that are important. One I'll call decentralization, the other I'll call periodicity. Decentralization, our electoral system is like federalism on steroids. It's not like there's 50 different systems, one for each state. There are thousands of different systems because in many, many states, counties or municipalities have a huge, huge impact on what the voting laws are for voters who live there. So it's a very fundamentally decentralized system. And because of that, courts are often a little bit unwilling to listen to arguments of, hey, you can't do that to me here because if I lived over there in that county in the same state, it would be different. Because, you know, then that may resonate, by the way, for those of you who are old enough to remember Bush v. Gore in 2000. But that kind of argument doesn't sit too well with judges because they know that we've, for whatever reasons, good, bad, or otherwise, accepted a very decentralized system where rules really are different from county to county and sometimes municipality to municipality. Periodicity, this is the simple fact that federal elections happen every couple of years, and you tend to get a lot of the new rules laid down by state and local election administrators, and the new challenges to those rules tend to happen right before the biennial elections. And what that means is you get a lot of preliminary injunction litigation where plaintiffs come in and say, I know we don't have time for a full-blown trial, but this is bad and I want to stop it. And the courts in recent years, following a Supreme Court case called Purcell, have basically said, we don't want courts changing the rules at the last moment. And this has been a mess of a doctrine. Some of the fundamental ideas behind it are not all wrong in that voter confusion can can flow from constantly changing rules. And lack of notice to voters can also be a problem if the rules are changing constantly right up to the election. However, the way Purcell is actually played out is kind of a mess. First of all, the court's been very unclear. Is this like just some huge thumb on the scale against plaintiffs and for defendants, or is it just part of the public interest prong of the usual four-prong preliminary injunction test? What is it? A second thing, sometimes it's not so obvious which way Purcell cuts. Let's say a local election administrator changes the rules in the weeks before an election. That change takes effect, and then plaintiffs run to court and say, I want to block that. Who is it that's changing the rules? Is the plaintiffs are trying to block it, or is it the election official who changed the status quo right before the lawsuit got filed? So it's not so obvious how that should cut, really. And then the third problem is because this stuff all comes up on PIs and then gets rapidly appealed, often all the way to the Supreme Court, you often get these like very abbreviated orders that don't say much. And I actually think that whenever there's a Purcell-based opinion, it should be, here's the order, here's the immediate opinion, longer opinion to follow, because we're going to flesh this out and really explain it. Because part of the reason the case law in this area is such a mess is that you often don't have full-length opinions explaining how this is all supposed to play out. Okay, one last thing I want to talk about is this distinction between your right as a voter to cast a ballot and your right as a voter to have that ballot counted. Obviously, both have to be effectuated to have political power, but they're really quite different. You might think that controversy about casting are all pre-election and controversy about counting are post-election. It's kind of true, but not really. In theory, judges could say about some elections, this one's such a mess that we need to actually have voters cast new set of ballots. We need to revote. There was a big revote debate, although not really that serious in the courts, but there was a big revote debate in politics in 2000 about Florida and the presidential election. But the reality is the courts almost never order a revote. It's extremely rare remedy. So when you get to the post-election period, it's not so much about who can cast a ballot, it's about that big pile of ballots waiting to be counted and what do we do with them. And there's a lot of litigation about that now, for example, in pre-election, and that's a good thing, probably in many instances, better to work those issues out pre-election than post-election. But what happens post-election is rather than engaging a lot of speculation about, gee, who will these ballots help or who will they hurt? Usually whoever's in the lead wants to stop the counting and whoever's behind wants to keep counting and count as many ballots as possible. So it ends up being this highly unprincipled and fluid discussion where a political party may take a position in one state that is diametrically the opposite of what they're taking in another state, and it gets really quite bizarre. This has been fought out especially about provisional ballots in the past. This is when you go to the polling place, they say, oh, Sam Hirsch, we don't see your name on our list of registered voters for this precinct. You can't vote a regular ballot. You can vote this provisional ballot. We'll stick it in an envelope and it'll have all your information. And then we'll try to figure out later if you're really a voter who should be voting here. Those things tend to take longer to get counted because you have to figure out whether to crack the envelope open and count it, whether the person's actually registered, whether they were in the right place, the wrong place, what that means, et cetera. Because the Help America Vote Act of 2002, which came out of Bush v. Gore, required provisional ballots to be permitted, but it didn't explain how they're going to be counted and sort of basically left that to state law, which has been a big mess. This year, we're going to have an explosion, probably an increase in provisional ballots because there's a lot of shifting of polling places going on because it's hard to staff all the polling places with COVID-19 going on and with the usual staff coming so much from senior citizens who are particularly vulnerable to the disease. So there may be more provisional ballots, but there'll definitely be more mail-in ballots. And therefore we have this possibility, and this is the last thing I'll leave you with because I think it'll segue into, after Kemba talks, into what Genevieve will raise. We have this potential for what is called either the red mirage or the blue shift. The red mirage is that because there may be huge piles, I mean like enormous piles of absentee ballots in some places not yet counted on election night, the election night reported votes will exclude those voters and will be weighted very heavily towards in-person voters because of the partisan valence that whole issue has taken on this year, although it hadn't in the past so much, but because of the president's constant crusade against mail ballots. We expect them to be more democratic than the in-person ballots, and therefore people fear, I think quite rightly, that President Trump will try to take advantage of the red mirage, saying on election night, I won here, I one there, and so on and so forth. And then saying as the real ballot totals trickle in the coming hours, days, and weeks, oh, those are all fraudulent. And that'll be labeled as the blue shift, when in fact all it is a complete and accurate count of all legitimate ballots. So that's something that we're really focused on. And I think Genevieve is going to talk a lot about the sort of post-election period and how it fits in with the laws under the Electoral Count Act and the 12th Amendment and other fun things like that. So anyway, I apologize for going on so long, but that's a sort of 100,000 foot framework that hopefully helps people as they read news stories about these cases, kind of put them in a framework.
Sure, thank you, Sam. That is incredibly helpful. And even though I work with you on these issues, I always learn something when you present on them. So I really appreciate that. That's kind of, the legal lay of the land. Where are we starting pre-2020 in terms of the law and how kind of voting rights work? But, as Sam pointed out, there's so much decentralization, and there are so many different ways to run an election, even though we do it at least every 2 years, often more frequently. And so, the part of what implicates election security and voting rights is just the administration of elections, and both intentional and unintentional, perhaps, interference with that administration. And so I'm going to ask Kemba, if you could give us some insight into the lay of the land in terms of technicalities, security, and the actual administration that all of these legal issues that get layered upon.
Thank you, Adrienne, and thank you, Sam. I could listen to you talk for the full hour. I appreciate you're giving us your time. Adrienne, as you know, I'm a cybersecurity lawyer at first and a national security lawyer at bottom. Came out of the department after 10 years and was in the predecessor to CISA in 2015 when the DCCC and the DNC were hacked, and was assigned this sort of collateral duty to provide cybersecurity legal counsel to what was stood up as the Elections Task Force at the time. What quickly became apparent to me was that elections infrastructure was unlike any other infrastructure that I had experience working in. And so I feel like my task here for this group is similar to the task I'd been performing over the last couple of years at Microsoft, which is bringing cybersecurity law together with elections law with this underlining decentralized infrastructure that we're all contending with. And I think, Adrienne, you're part of my group that sort of talks about these issues. So just to give you another perspective, a technology perspective, and full caveat, I am not a technologist. I am a lawyer, but I can deal with the best of them. So just bear with me. There are sort of 4 buckets of technology involved in the voting system, the way I like to think about it. The technology associated before the vote, technology associated with casting your vote, technology associated with counting, reporting, and verifying your vote, and then sort of ongoing maintenance. So let's start with before the vote. So before the vote, that's really voter registration. Your voter registration portals, where voters can register to vote through their local DMVs. They can do it online. They can do it at other public agencies in their state or municipality. That includes technology associated with local elections websites, right? These are websites that are run not necessarily by state or local officials, but where you can check whether you are registered to vote. It includes voter registration databases, and it includes poll books. So that's the bucket before the vote. The next bucket is casting the vote. That will include DRE machines, the direct recording electronic machines that were the direct result of HAVA 2002, ballot marking devices, and then optical scanners. And we'll talk about challenges associated with that bucket. And then there's the counting, reporting, and verifying the vote. Those are voting tabulator machines, election night reporting systems, ballot reconciliation. And we won't talk about those systems as much in detail today, but that's another bucket. And then finally, the ongoing maintenance, sort of the updates to all the technology associated with voting and election systems. Now, Sam touched on many of the challenges that I discovered while practicing cybersecurity law at CISA. just the sheer decentralized nature of the system is its own challenge. It leaves vulnerable vulnerabilities that are technological in nature, but also human vulnerabilities sort of exposed, and it's sort of a cybersecurity person or a national security person's nightmare, right? There are something, I have a 4-year-old, so excuse me. There's something close to 10,000 elections jurisdictions in the United States. Many of them are local and I mean, at the municipality level. Approximately a third of those are in Wisconsin and Michigan, if you can give you some sort of scale. So imagine 10,000 election jurisdictions. Some of the challenges then for cybersecurity are, who do you deliver cybersecurity services to, right? I mentioned earlier that voter registration portals are, you can register to vote at your local DMV. Who owns that system? Is it your local elections administrator, or is it whoever runs the Department of Motor Vehicles? Mommy's teaching me now. Yes. Okay. So if you are receiving technical assistance from the private sector, who do you enter into a non-disclosure agreement with, right? If you're offering those services for free, which laws are implicated? Are they the state procurement laws that that prohibit free services from the private sector? Is there ethic laws? Is it where is that line? And then if you're providing cybersecurity services or technical services as a federal government agency, who's able to provide consent in order to be able to comply with the Fourth Amendment? Because when the federal agency provides cybersecurity services, that can involve everything from shoulder surfing and looking at the content to actually pen testing, penetration testing, trying to penetrate into your network. Those are searches under the Constitution, right? So that's just a basic challenge. That's one type of challenge. The other type is that Sam alluded to the Help America Vote Act earlier. HAVA establishes federal responsibilities for testing, certification, training, technical assistance, and grant making among all these election systems. But the scope is defined. Voting systems is defined. As defined, does not apply to all the technology associated to before the vote. So it's doesn't apply to poll books. It doesn't apply to local elections websites or voter registration portals. It might apply to everything associated with casting votes, but it doesn't necessarily apply to everything for counting and reporting and verifying reports. Importantly, it does apply to risk limiting audits, that kind of thing, but not necessarily election reporting systems. So those get left out of the federal government assistance for cybersecurity. Yes, I teach at night too. So there are real challenges there, right? Because HAVA doesn't cover everything. So now what do state and local election officials do? They might rely a little bit more heavily on the private sector in those spaces where the federal sector can't. So for example, at Microsoft, where I work, one of our challenges might be that voter registration or poll books are stored somewhere in our cloud, right? We don't necessarily know who's storing what workloads in our cloud in order to be able to provide the unique services, cybersecurity services that customer might need. So one of the big challenges is first, finding out what's in our cloud, and then targeting cybersecurity services to that customer and making sure that we comply with all procurement ethics laws when we do so at cost or at low cost, right? You would think some of the simplest things, some of the most obvious things would be simple, but they're not. And I'm sure Amazon Web Services has similar issues, and as does Google. The other challenge, at least I'm trying to give you both perspectives from the government side, is when the government designated elections infrastructure as critical, there was a lot of pushback. There were a lot of constitutional questions associated with that. Is this a federal takeover of our election systems? So even just trying to designate election systems as critical in the wake of the 2015 hacks, the 2016 election, was challenging in and of itself. Once that was done, then the opportunities really started to flow, right? Elections vendors and elections administration officials, federal government, state and local governments all began to collaborate a little bit better, share better information. But the biggest hurdle was designating it critical infrastructure and getting everyone to understand that it was really critical and what that meant. So those are some, I just wanted to set up for you sort of the technology involved, some of the challenges associated pre-2016. And I'm excited to hear what Genevieve has to say about mail-in voting and some of the unique challenges associated with COVID-19, because again, casting the vote will include now in a significant way mail-in voting, and then that means optical scanners are much more in use at this moment in time, and there are a whole host of cybersecurity issues associated with using optical scanners. Did I cover everything, Adrienne, that you needed?
Yeah, I think that kind of is a great kind of background and overview that, this is not just legally complicated, but it is technically complicated. And I think that sets us up pretty well for Genevieve to explain how kind of the exigencies and innovations of and issues of the past year, multiple fronts kind of intersect both with the legal kind of issues that Sam has laid out, and then kind of the technical and administrative points that you've laid out. So Genevieve, who I know has been working incredibly hard and doing amazing work on dealing with the potentials for election-related emergencies and exigencies. What are we seeing in terms of these kinds of expected emergencies, things that have already happened that we might prepare to guard against? And how has COVID, impacted that? You've been doing this work well before COVID was an issue, right? And so I'd be interested in hearing your perspective both on how to prepare for election emergencies generally, given this background, but also how has COVID impacted those preparations?
Well, hi everyone. Thanks for having me. So we could probably do a whole session on each one of those questions, Adrienne.
Right.
Yeah, so I, in addition to my work with Protect Democracy, have been working with the National Task Force on Election Crises, which Adrienne mentioned and Sam is part of. We started a year and a half, maybe more ago, to think about, what are some of the emergencies, the crises that might unfold that would affect the ability of the country to conduct a free and fair and successful election. We thought of all sorts of things, hurricanes, terrorist attacks, and started thinking them through. What did we not plan for? It was the pandemic. So in many respects, for all our planning, we are already in the midst of the crisis, right? Which is the coronavirus. But we have many things layering on top of that as well. It seems like every week brings a new challenge of some sort, new questions about how we choose a president in this country. One thing that we saw throughout the primary process is that in many respects, states have not been quite ready to understand and exercise their emergency authorities. So that it's really been a steep learning curve in many respects. I suppose on the upside, we did have the primary season in the context of the coronavirus, and so many states have had a chance to learn and adjust for the general election. But there are still significant challenges. So you think about how has COVID changed the election landscape? First and foremost, the nature of voting has changed in some pretty fundamental ways. Most notably, both Sam and Kemba referenced the increase in absentee voting. There's some back and forth about what are the right terms, and different jurisdictions use different terms: vote by mail, absentee voting. I'm going to say absentee voting just sort of as an all-encompassing term, as meaning voting other than when you go and vote in person. But because of concerns over the safety of in-person voting, of course, we've seen states have to very rapidly expand their capabilities for large volumes of absentee voting and change their laws and practices accordingly. And so In many states, that means doing away with excuse requirements that, significantly limit who can vote remotely or absentee. And, from a voter perspective, it means changing to the deadlines for requesting and returning absentee ballots. And from election officials' perspectives, changes to, the timelines and other rules around processing ballots. Some of what Kemba was sort of referencing, I think, at the end of her remarks there. So we've seen a really rapid sort of expansion of preparation and changes in the rules, which, in any time you try to change the rules of any sort of game quickly, there's inevitably confusion and disputes. And so we've seen, election litigation is not uncommon. We see that all the time. But this year we've seen just a huge spike. I think, I don't know the exact number. There are different websites that track it, but I think we're in the sort of over 300 cases specifically inspired in one way or another by the coronavirus. And some of those are still pending. So there are some jurisdictions, including some key states, where we don't know exactly what all of the rules will be. And people are, in many places starting to vote. So it's a very interesting landscape. And it's not just voting by mail, which is, of course, one of the more unique aspects of this election cycle. But there's a need for, safe in-person voting. And there are lots of reasons why that is, but that includes the fact that there are some communities that just can't or won't vote by mail as easily as others. And so having safe in-person options is critically important and yet also very challenging. So something else we saw during the primaries, you saw images of long lines and reports of people risking their health and the like, and poll workers not reporting to work and that. So there are a lot of challenges around that. One of the key challenges this cycle is, like I said, poll workers. And there are many, many efforts underway to recruit folks, but it's a challenge. It's a challenge in any election, but in particular this year. And so, overall, the pandemic has just really highlighted some of the weaknesses in our election systems, and the real need to have sort of robust options for the ways that we vote. I would say sort of another bucket of how COVID has affected the landscape is really with respect to the post-election period, or we say like, election night and thereafter. First, sort of Sam mentioned this, results are going to take longer, right? Absentee ballots that come by mail require, much different processing than in-person ballots, right? Ballots have to be opened, checked, then count, maybe scanned, then counted. There's more work that goes into that. And given the expected volume, we can expect that with that will take time, right? So in a country that's, very used to having results, or at least projected results, they're never official, but projected results on election night, I think we're going to have to adjust our expectations. And that's okay. It takes time to count ballots, and that's what election officials should be doing. But the expectations, of course, matter. The good thing is that, we're seeing in polling that people really are started to catch on to this. And so the vast majority of people polled will now say they don't necessarily expect a result on election night, and that's probably a good thing. We're also, I think, going to be seeing an increase in post-election disputes. Maybe, we shall see. The closer the election is, the more likely disputes are to arise, and the longer they are likely to last. An election that's sort of a blowout one way or the other arguably won't be quite as fraught. But, we haven't seen a really contested election since Bush v. Gore in this country. And in fact, the last time we had a contested election that went all the way to Congress, and I'll say what I mean by that in a second, is 1887. So we have sort of the ingredients for a really unique scenario in the United States this election cycle. Most people know that when you vote for a president, you actually vote for electors who vote in the Electoral College. People get that sort of general idea for the most part, but we really haven't had to think that much about what happens after that, right? You cast your vote, you hear projected results, and then a number of things sort of happen behind the scenes, and there's an inauguration on January 20th, and sort of pro forma in that respect. But there are lots of reasons to think this year that we may have to sort of dig in and understand what happens during that time frame between November 3rd and January 20th. And it's all governed by a combination of the Constitution, which doesn't actually say a whole lot, or as much as you think it might, and this arcane, incredibly complicated law from 1887 called the Electoral Count Act, right? And that's what sets the federal deadlines for when states have to, finish counting their results and certify them and send them to Congress. And then Congress actually, I'm not sure most folks actually realize this, formally certifies the results. And the statute provides some guidance on how Congress should deal with disputes that arise over how or whether to count the electoral votes that states have submitted. So it's extraordinarily complex, and there's a risk this year that we'll see that law really come into play in a way that it hasn't before. So there's a lot of folks, including the folks on this call, suddenly starting to try to understand this law that we've not paid any attention to. It's been very challenging. And with all of that comes just sort of an increased opportunity for, for lack of a better word, I'll say shenanigans, right? Complexities over voting by mail and the like, the sort of different touch points and different political actors that may be involved. And there's a lot of concern this year about, interventions that we haven't seen before. And so that may include things like, sort of artificially trying to stop counting ballots. I think Sam referenced this, that we've heard President Trump repeatedly question the security of voting by mail, falsely and without evidence, but nonetheless is setting the stage for challenges. We've also heard him say that the results on election night need to be the final results, which has absolutely no basis in law or reality, and yet it's about setting expectations. And so there's concerns that there'll be attempts to actually sort of see that through. One thing we're hearing this year that I never thought about before, I don't know that anyone else has, is the role of state legislatures in choosing the president, right? The Constitution actually gives states, through their state legislatures, the ability to decide how presidential electors are appointed. And of course, we have elections where we go by the popular vote, and we have for over a century, but there is this constitutional provision, and there's a question of, what if we just don't know the results and it's, time is ticking and these deadlines are approaching? Or what if the results are so disputed that we can't reasonably, know what's the right outcome? What then? And will state legislatures sort of try to reclaim their authority under the Constitution to decide themselves and appoint electors? Something we've never thought about before, but that we're seeing a lot of preparation for this year. So it's just a very different post-election landscape, potentially at least. Fingers crossed that none of these things come to pass. And many of these, I think, more extreme crises that we're worried about are small in probability, but not so small in impact should they come to pass. So there's lots of preparation going on. And then just, lastly, and I'm happy to answer questions, of course, just want to say a little bit, Adrienne, about what, with all of this, this sort of scary picture of all that's happening and could come to pass. What do we do about it? Just so if that makes sense, just a few pointers for folks on, yeah. So one is, some of these will be more obvious than others, but one is about voting, right? Our sort of primary responsibility as citizens, right, is to vote ourselves and be prepared to do so. And so, every voter has an obligation to stay informed, understand the laws and the rules in your jurisdiction, and pay attention to changes, right? We saw this during the primaries. We're still seeing it now that there are changes still happening. We're hearing from public health experts that we may see spikes in virus transmission and risk as the election comes closer. So there may be more changes to come as states are sort of grappling with that on an emergency basis. So pay attention. Make a plan for voting. This is not necessarily something that we've all given a ton of thought to in the past because it hasn't been quite as fraught, at least across the board, the way it is during the pandemic. So just make a plan, understand the rules, like I said, and figure out how you're going to vote. And I'd say, I'd put a very strong thumb on the scale for voting early, however you prefer to do that and whatever your option is in your jurisdiction. And so that could be in person or it could be by absentee ballot. But plan ahead, because last minute decisions can backfire. For example, you may find that the lines are longer than you expected, that the risk is higher than you expected, in November 3rd as compared to now. You have to make some early choices about whether or not to request an absentee ballot. And once you do that, your ability to show up and vote in person might be affected. So you really got to understand what your approach, what your game plan is. Volunteer, right? So there's a lot of folks I'm sure on this call with a lot of skills, and there's lots of need for it. And some of those, are lawyer skills, right? There's going to be a huge voter protection efforts in place across the country. And so there are lots of opportunities to volunteer. One website that comes to mind is We the Action, that sort of connects volunteer lawyers and others with organizations that need help. But even if you're not a lawyer, whatever your profession and your background, like I said, sort of at the top, poll workers are desperately needed across the country. And so if you're able to volunteer and you feel safe doing so, there's a great need. And then last, I think, sort of getting back to this point about the uncertainties and the room for shenanigans in the post-election period. I think it's important that voters understand, right? So not just the rules in how to vote, but understand what the landscape looks like and actually how we choose the president. There's a lot of, I think, sort of strength in knowledge, and there are a lot of reasons to be vigilant and concerned this year, but not reason to panic. And so, understanding that we actually do have processes and procedures in place to sort of get us through many of the things that we're worried about is very important, because the last thing we want to do is sort of add to sort of a crisis of legitimacy where the American people don't trust the election unnecessarily, and all the things that may flow from that. And so you can do that sort of as just a matter of personal responsibility, but also just talking to your friends and family about the election, understanding that election night is going to look very different this year, and that's okay. Maybe your election parties will be a little different. Maybe you'll have an election week party. I don't know. But sort of we have, all participate in managing our expectations. One of the task force members that Sam and I work with, Josh Geltzer, wrote an article that I thought was really persuasive, where he argued that, yes, there are lots of crises to worry about and things happening, but really maybe the thing to be most worried about is this sort of crisis of confidence in American people losing faith in our institutions and in the election. And so that's really all on us. You don't have to be an expert in order to sort of combat that. And many of the things that we're worried about happening really are much less likely to happen if we don't let them. And so I think, sort of guarding ourselves with information and confidence and all the like is critically important this year. And sort of the best medicine against disinformation and false claims is an aware and prepared electorate. And so with that, I will step off the soapbox.
Oh, that was fantastic, and I have to say I'm feeling more upbeat at the end of that than I thought I would. So that's great. So I mean, you all provided just so much fodder for thinking about everything that is going on right now, how the election could play out based on technical capacities, cybersecurity concerns, voting rights law, and then particular exigencies that we're facing with COVID and just legitimacy. So I want to kind of turn to our audience and see if anyone has, we could go on and on, but if anyone has any questions as we kind of wrap up the lunch hour for our fantastic panelists. I think if you want to ask a question, you can open the Q&A button at the bottom of your screen and just type something in. All right, so we have a question asking, what resources would you all recommend that we can share with different organizations to show the process of the election as it will be, and what happens in a contested election, etc. So do you have any thoughts, like what are good resources to kind of pass on?
This feels like a really softball question to me.
It really is. I was going to say, Genevieve.
Like I mentioned, the National Task Force on Election Crises, which is a cross-partisan task force with really impressive experts from across disciplines. We have experts in election law like Sam and others who are more academics. We have Vanita Gupta and Sherilyn Eiffel, who run our largest civil rights organizations. We also have former Republican Cabinet Secretary Michael Chertoff and former head of the RNC Steele. And so it's really a really interesting group, like I said, cross-partisan, multidisciplinary, and sort of exists exactly for this purpose, right? To identify crises and sort of educate the public and the media and those who really have a public voice on what's normal, what's not normal, what the rules are, et cetera. And so the website is electiontaskforce.org. And there's a whole bunch of stuff on there on our resources page that answers these questions. The Electoral Count Act of 1887, something you never wanted to know anything about, but explains what it's all about. It explains election contests. It explains why actually it's not okay for state legislatures to sort of usurp the popular vote if they're concerned the results aren't turning out the way they like, and much more.
Thank you. So as Sam and Kemba, do you have any other thoughts on how you direct folks who are trying to inform themselves about the process, and perhaps so maybe they can also inform others and address maybe this legitimacy issue that Genevieve was mentioning?
I would just add, before I know Sam has something wise to say, I'll just add, you can go to www.cisa.gov for some basic information about voting and the systems involved. And you can also get legitimate, great information, if all else fails, from the National Association of Secretary of State's website or the National Association of Election Directors. I think those are two credible, sort of .gov spaces for you to find information.
I would just add, if you're particularly interested in sort of legal dimensions and litigation, there's a lot of good trackers out there, but the websites of the Campaign Legal Center and the Brennan Center for Justice are always first rate.
That's true. Well, thank you. So we have a few more questions. First, we have a question about how much, I think this is a good kind of like prospective question. How much, of the concerns about legitimacy, potential chaos, snafus, can Congress actually fix for the next election? And maybe we need to perhaps broaden that question and think about, like, because so much of this is administered locally, what are the kind of areas for reform that perhaps we should have implemented before we're in the Purcell window, like 4 weeks before Election Day, that we can start laying the groundwork and thinking about going forward for next cycle?
Well, I think the question came from Lois Schiffer. So first I have to say hi, Lois. I had the opportunity to work with her in the Obama administration, and it was one of the great pleasures of my 8 years there. I think that elections are hard to administer and will never be perfect. But there's a lot that can be learned, first of all, from the fact that we do have this decentralized system. In some places, things work better than in other places. And also that we can look to other countries and see their experience. And I think from that has been distilled a set of reforms that have been put together in a comprehensive package, which was the first bill passed by the Democratic-led House of Representatives in this Congress. It died, like many things do, in the Senate. But that's H.R. 1. It's a huge package of electoral reforms, not all of which speak directly to the kind of issues we've been talking about today, but a lot of them do. And I think if you go to congress.gov and look at the materials on H.R. 1, you'll get a flavor for just how broad it is. Most of the Democratic Party has been solidly behind the bill, and it was put together with assistance from a very broad coalition of voting rights and civil rights organizations. And if it were to pass the next Congress and be signed by the next president, I think that 4 years from now, we'd be in much better shape.
So we have a couple more questions that we can get in the lunch hour. The first from Noah Bocat-Lindell. Hey, Noah, one of our wonderful colleagues in the election law practice at Jenner and a kind of voting rights expert in his own right, is asking about the nature of the expedited nature of the litigation that's going around COVID and like COVID measures, and if that's going to affect the quality of the court's reasoning in addressing these issues, and if that's going to create bad precedent. I mean, I'm thinking what Sam said earlier about maybe you want to just issue a quick order and then provide your reasoning later. I know Noah points out that there are a couple of recent decisions in the Fifth and the Seventh Circuits about challenges to absentee ballot rules that in the process of their reasoning rule that the voting amendments don't actually require heightened scrutiny, which potentially could severely limit the right to vote. So what do you all think about that?
Well, I'll jump in. I think Noah's put his finger on a real problem. I don't think my reform that I mentioned earlier would completely solve it, but it would help, which is to say, when especially appellate courts and Supreme Court have to deal at rocket speed with some of these issues, they should reserve the option of coming back later, even months later, with a carefully reasoned opinion backing the shorter opinion that they issue with the actual order. Because part of the problem is, we're getting a lot of it this year because of COVID, but we always get a pretty substantial amount of this immediate pre-election day litigation. It is horribly rushed, and it does lead to bad decisions and bad rationales, even for good decisions, as well as the bad ones. So a cure for that, a partial cure for that, would be this, order with a short opinion, long opinion to follow kind of approach. And I think Rick Hassan has also recommended the same thing. So that wouldn't cure everything. We have some folks who sit as judges who have very peculiar legal positions on certain issues, and that's just part of our system. But I do think that more carefully written, less speedily delivered opinions would help somewhat.
Genevieve or Kemba, anything to add to that?
That seems right to me. I think we've already seen this challenge arise, right? Well, first of all, many people are still trying to understand Bush v. Gore, notwithstanding the fact that there's a line in there that says it basically should not have much precedential effect. We're still grappling with what it means, and that was a decision rendered in a short time frame. And then RNC versus DNC, the Supreme Court decision that came out of Wisconsin, sort of similarly very short, very quick. That touches on a lot of the concerns that Sam has highlighted on Purcell and when are changes okay and not okay, and that was the height of the pandemic, really. Knock on wood. So yes, I think that is something to be concerned about.
All right, well, we have one other question from Billy Freeland. Hi, Billy. Billy is one of my dear friends from law school, who is a total politico and knows a lot about this area. So Billy asks, with the 11th Circuit ruling that Florida's requirement that people formerly incarcerated for a felony must actually pay fees before they can register to vote, despite the referendum that was passed by Florida voters. So can Congress actually pass a law that says that this is a poll tax, or is there a way to label this a poll tax, or is it just still a matter of constitutional interpretation? So I don't know if folks have any thoughts on that decision that came out, I guess, a couple months ago at this point, maybe a month ago. So.
Great question. I'm not 100% certain the precise answer to the question Billy asked, but I think Congress in general has very broad powers with regard to federal elections, elections for federal office. And it is exceedingly difficult, although it has happened at various times in various ways, for a state to maintain two parallel systems, one that complies with all the rules that apply to federal elections and a different set for, say, odd year elections, mayoral elections, and so on and so forth. So the reality is that once Congress legislates about what's appropriate, not appropriate in federal elections, that usually drives in almost all or all of the 50 states how they conduct all of their elections. And Congress could speak to this exact issue as to federal elections. Whether it would do so by labeling this a poll tax or just prohibiting disenfranchising people on this basis, I don't know. I think probably the latter is more straightforward.
Thanks. Well, I just want to thank everyone again for joining us, for Sam, Genevieve, and Kemba, and lending your incredible expertise to us today. And I certainly feel much more informed and about these issues that are going to be so important in the next few weeks. I'm ready to go out and protect the vote and educate my friends and family. But before we end, I also just want to mention to everyone who is interested in these issues, the ACS DC chapter is having another event next week, coming up on October 15th from 7 to 8 p.m. Eastern time. That is specifically geared towards training people to help protect the vote in 2020. We're working with an expert from the Lawyers Committee for Civil Rights to help show folks how they can get involved in manning voter protection hotlines and involved as poll workers, as Genevieve said, that's so important. So if you're fired up and ready to go from Sam and Genevieve and Kemba's presentations, I strongly encourage you to join us next week for our training on protecting the vote. So yeah, thank you all so much for lending your time and expertise today. We really appreciate it.